Good afternoon, everybody. Hope you're well and enjoying the well-needed sunshine. Good afternoon. Welcome to the next of our Essential series. These are topical, engaging, technical webinars on wealth and wellness with the leaders in the private client world. I'm Lottie, founder of the Jura Society Network and Private Client Consultancy, focusing on women, wealth and well-being. This afternoon, we are joined by the brilliant Katie O'Callaghan, and we're going to be learning everything to do with international divorce and the impact for multi-jurisdiction relationships. If you do have any questions, pop them in the chat. We'll have time for Q&A at the end. But other than that, welcome to Katie O'Callaghan.
Thank you, Lottie. Hi. Thanks, Lottie. Thanks for having me. As Lottie said, I am going to talk a little bit today about international families and relationship breakdown. So I am a partner in the family team at Boudall Hatfield, which is a law firm servicing private client individuals and their needs. Primarily, I spend most of my time dealing with divorce, the financial consequences that flow from that, children arrangements as a consequence of parental separation, and also on the other side, trying to mitigate the risk of divorce in advance by thinking about asset protection measures that people can put in place to avoid ending up in a situation where they have an acrimonious or difficult piece of litigation at the end of a marriage. So I'm now hoping Lottie might be able to load some slides, hopefully. Thank you, Lottie. Thank you. So as you might imagine, it's pretty rare now to have a family that doesn't have some form of international connection. It's rare really to have a family that are completely linked solely to one country. It might be through nationality, it might be through living abroad, but being born in a different country, owning a holiday home or other offshore assets. So the focus really of today is to talk through how that is impacted when people divorce in England. So I thought I'd start off by talking about where people can divorce and what happens when a family has connections to multiple countries and a marriage breaks down. So the first really simple point is that it doesn't matter where you got married, as long as you had a valid legal marriage in that country, any country in the world could deal with the divorce. And so if you get married in Barbados, it certainly doesn't mean that you get divorced in Barbados. What matters is really focused on where you're living at the time your marriage breaks down, and or where you're from or where you're domiciled. And so in England, for example, the test for whether England can hear your divorce is, are one or both of you living or habitually resident here, or are you from here or domiciled here? And other countries have similar tests. So if a family has connections to more than one country, it may well be that a divorce could take place either in England or, for example, in France. And so how do you decide where or which country should hear the divorce? Well, because England is known for being very generous to the financially weaker spouse, you can often end up in a situation where financially stronger spouse, being stereotypical, often the husband, wants to divorce, let's say in France, because the financial outcome would be far better for him in France than in England. And wife wants to divorce in England because she has had advice that she will end up financially far better off if the English family courts can hear the divorce. And so you can end up in a situation, as I've put at the bottom of this slide, where you can have a dispute before the divorce is even kicked off to determine whether England or France should hear it. And if they can both divorce in either country because they're living there or they're a national or were domiciled in either country, then the test really becomes, which country do the family as a whole have the strongest connection to? And so if you have a scenario where, let's say, husband is French, is from France, was born there, lived there throughout his childhood, but has primarily lived his adult life in England, wife is English, and children are at school in England, family home is in England, even if there's, let's say, a holiday house in France, the likelihood, looking on that factual scenario, is that England would succeed in having the ability to hear the divorce and therefore the finances. So there could end up being a sort of test, a factual look at what the reality is on the ground for that family to determine which country is best suited. And you can end up with people being quite strategic, in all honesty, in seeking advice if their marriage is potentially not in the best of health before, let's say, they have established a strong connection with this country, and then ensuring that they set themselves up so that they have the ability to divorce here, have habitual residence here, because they know that from a financial perspective, they will be in a better position to divorce here. So that's the main test if you have two countries or three or more where a spouse could issue divorce proceedings. So we then move on to the second slide, which is once you've established that you are getting divorced in England, that means, as a kind of flow from that, that the English court has the ability to then deal with the finances and the consequences of the marital breakdown in terms of the division of your assets. And the English court, as I mentioned, is known for being very generous to the financially weaker spouse. And really, that's because it has very wide and extensive powers in relation to money. So to give you a flavour, an example of what the court can order, it can order a transfer or a sale of property. It can order cash payments from one spouse to the other. It can split pensions and credit some pension from one spouse into the other person's name. It can vary trust interests, although that's quite rare. It can order spousal maintenance, and it's known for being more generous on that front than other countries too. So what happens if you've got assets overseas and you're getting divorced in England? Well, the key point to be aware of is that powers are not limited to just assets based in England. So you can make orders on worldwide wealth in the English family courts. And so if the main asset base is in England, but there are offshore investment portfolios or accounts, or as I said earlier, a holiday home, foreign companies, offshore trusts, all of that is relevant to the English family court when considering how to divide up these parties' assets. And the first stage really is that you would have to disclose the existence of all of these assets in quite an onerous disclosure document if you end up dealing with your finances through the court. And that requires supporting documentation in relation to each asset, balances, updating valuations, supporting statements and evidence. And that includes any asset that is held abroad. And it includes, for example, assets held with third parties. So if you had, in the example I gave earlier, the husband with a French holiday home that perhaps he owns with his siblings or his parents, just because that's A, in France, and B, held with third parties, doesn't A, prevent him having to disclose the existence of it and provide detail about value, etc., but also doesn't prevent, theoretically, the English court from being able to make orders against that French property. Now, having said all of that, what the English court will want to do is to try, insofar as it's possible, to make financial orders against assets that are based in this country. And the reason for that is because if the order relates to assets offshore, for example, the court orders that a foreign property must be sold, or that money should be transferred from an offshore account to a spouse, there are potentially more risks in relation to enforcement. So even if the court makes the order that says this property should be transferred or this money should be paid, if the financially stronger spouse is potentially inclined to breach the order that's been made or not comply with it fully, there are much more in terms of obstacles in place for the financially weaker spouse to try and actually enforce against that order, because the asset is not in this country. Where the assets are in this country, if a spouse doesn't comply, it's far easier for the English courts to order and kind of take control to enable that spouse to receive the funds that were envisaged. So if there is a mixed asset base, some offshore, some in England, the English court will try, insofar as it's possible, to ensure that the financial orders are made from the English assets in the first instance. But as I said, the disclosure requirements are prevalent for any asset wherever it's based. And there is risk in relation to any foreign asset that it's exposed to the possibility of an order being made against it. So we then move on to thinking about the treatment of prenups or postnups in a divorce that is dealt with in England. And as I said at the beginning, many families have international connections. Families who get divorced here may not have lived here their entire lives, and you often have families who have lived abroad, who got married and spent the first few years of their marriage in a different country. They may have signed some form of marriage contract or prenup in that country before they got married, and then they move to England and end up establishing their home here. They then end up divorcing here because at the point of a divorce, this is where their kind of primary base is, their strongest connection. And then there's a question as to how the English courts would treat the prenup from a different country on divorce when considering the finances. So the starting point in relation to any nuptial agreement, when I say nuptial agreement, I mean a prenup signed before a marriage or a postnup signed any time after the marriage, and whether it's English or a foreign agreement, is that they are not automatically binding in this country. So it doesn't give you a 100% guaranteed level of protection in relation to the possibility of that being attacked on divorce. Having said that, the English courts are now increasingly respecting and upholding these agreements, and they have a strong chance of being upheld, provided they've been entered into properly. And what does that mean? Well, we now have fairly clear criteria from the courts as to what they expect a prenup to look like and how that process has come about to sort of test or stress test whether that prenup should be upheld. And so there are 4 key criteria. 3 are really simple and 1 is far more complicated. So the first is that both of you should have independent legal advice on the sort of nature and effect of the agreement, so you understand what you're signing. The second is that neither party can be put under pressure to sign the agreement. And usually if it's a prenup, you try in English law to sign them at least a month before a wedding date to try and show that. The third is that you must provide full disclosure of your finances at the time of entering the agreement. And the fourth, and this is the one which is more challenging and is referenced on the slides, is that it must be fair to the financially weaker spouse. And so if you have a prenup that simply ring fences all of your wealth and leaves your other half unable to meet their needs on divorce, then that spouse has, the prospect of seeking to attack the agreement in the event of a divorce on the basis that it's not fair. So that's the criteria that if, as an English family lawyer, we are asked to put a prenup in place for a client, we would seek to comply with all of those criteria to give it the best chance of being upheld. Foreign agreements don't always comply with all of those criteria, as you might imagine, because if you're entering a French marriage contract in France before your wedding, it's unlikely you've spoken to some English family lawyer to check that if you move to England in the future, your French marriage contract would be binding on the English courts. So you do have lots of scenarios where a foreign agreement doesn't necessarily comply with all of those criteria. And the courts will still consider the agreement as a factor which needs to be taken into account when considering how to divide up the wealth. And increasingly, as I said, the courts want to respect parties' autonomy and their choices in terms of signing these agreements, but it will still ensure that fairness and needs are met. And so with a foreign agreement, it will look in more detail about whether the criteria in that country has been complied with. So if it's a French marriage contract, it would want to understand whether the criteria to sign a compliant French marriage contract has taken place. But it will also apply its own law primarily to decide whether that agreement does in fact meet both parties' needs. Is it fair? And if it doesn't believe that it is, then it still has the power to disregard its terms, either in part or in whole. And an important point to note is that even if a prenup, foreign or English, is not fully upheld by the court does tend to treat the existence of the fact that these parties signed something as a drag on the financially weaker spouse's claim. So often it is a factor, even if the agreement doesn't end up being upheld, in how the assets should be divided, because of the very fact that these parties did sign an agreement, and therefore the outcome should potentially be different to if there was no agreement whatsoever. And actually, now there are an increasing number of divorces going through the courts where prenups are being tested and one party is seeking to attack them, and the courts are having to decide whether or not these agreements should be upheld or not. They are becoming far more common, and I suppose one piece of advice for people, particularly if you're the financially stronger spouse, is if you are contemplating a move to England, or you already have moved and you have a foreign agreement in place, it might be worth a conversation with a family lawyer to determine whether you should consider putting in place, an English form of agreement by way of added protection. So the final, slide, final one before any questions, is sort of turning our attention away from the finances and actually thinking about children and international impacts on separation or divorce. And just to be clear, this slide could apply to unmarried parents or married spouses who are separating and divorcing. And you'll see at the top of the slide, it says, what happens when one parent wants to move abroad with children post-separation? And as you might imagine, again, this is becoming more commonplace, where you may have a family with international connections. They are based, let's say, in this country as part of their, married life, and the family base themselves here. During the marriage breaks up, and the parties separate. They deal with the finances. They also have to deal with arrangements for their children. And it's not uncommon if, for example, one parent is from a different country, that parent may wish to consider relocating back to their home country with the children as a consequence of the marriage breakdown. So you might have, again, using France as an example, a French national mother who's living in England. Husband is here because of his job. She doesn't have a great support network. She wants to be back with her family in France. They haven't been here very long because they only moved because of his job, and she wishes to return to France on divorce. Now, the first crucial point to be aware of is that you obviously, hopefully this is obvious, need the consent of the other parent to move abroad. You can't simply move without their consent. That would then be treated as abduction, which is a serious offence. So you must have the parents' consent. If you don't have their consent, then you have to apply to the court under the Children Act to ask for the court's permission to relocate. How does one decide which court should deal with it? It's based on, as it says on the slide, the child's habitual residence. So if mum wants to move to France with the children, but they're currently living in England, England would be the court that would have to deal with whether the children and the mum should be allowed to move to France. And there is only really one test when it comes to relocation of children, and indeed all arrangements relating to children. If you go to court, the test is what is in the children's best interests. So it's not any entitlement on behalf of either parent. It's not about the parents' interests. Primarily, it is about, is it in these children's best interests to relocate from their existing country to France? And as you might imagine, there are lots of factors that play into a child's best interest. And one of them, let's be clear, is, the happiness of their respective parents. And so in some cases, you do have mothers who want to relocate, relying on their own mental health or state of health as a reason why it's in the children's best interest to relocate, because they're miserable in their existing country, for example. What the court wants to see from the parent who wishes to relocate is a very clear plan in place. It can't be a sort of rushed, ad hoc, unprepared decision to apply to the court. The court wants to see this has been really well thought through. The person who wishes to relocate has thought about housing, education, support network, travel, ability for the other parent who is left behind to see the children on a regular basis, and to have considered how that relationship can be maintained as best possible. And obviously, there's a great big difference between a proposed relocation between England and France and England and Australia. So every case is determined on the individual facts of that case. And as you might imagine, these ones are quite difficult because there is no real compromise position. You're either staying or you're going, and there's no real middle ground. So often they can be quite difficult to resolve, and they go to court probably more frequently than other child-related disputes. I will stop there because I think I've been about 25 minutes and I've whistled through all of the themes that I planned to cover. So if anyone does have any questions on any of it, please do shout. And Lottie's reappeared.
Hello. Oh, brilliant. Always wonderful to know exactly what to do and what not to do when it comes to anything legal and nuptial. Okay, so I obviously have some questions for you, always. Yes, okay, it's great that a court order might happen for multi-jurisdiction assets, but actually how likely and easy is it to actually recover them?
You will read, people will have read cases in the press where people have these, orders that award a wife, tens of millions of pounds. And then actually the wife has not managed to get her hands on any of the actual assets to enable that award to be complied with. it can be very difficult, and it requires the kind of cooperation of the other country and what mechanisms they have in place to recover those assets. It's not straightforward and it's not cheap. Theoretically, if one spouse has failed to comply with the order and is in breach of it, you should be able to recover your legal fees in having to enforce. But again, it's all kind of circular, isn't it? You've got to be able to get your hands on some of the assets to enable all of that to happen. Which is why, as I said, the English court wants to try and, utilise the assets in this country as a start point. And enforcement considerations are a big feature of a case where there is lots of offshore wealth. The court will want to try and ensure that there is as much sort of safeguarding in place to ensure that the spouse actually receives the award that they've been entitled to receive.
That's really helpful to know. Thank you. We're talking a lot about courts as well.
Yeah.
What alternatives are there? Because this, we always think sort of courts, that's the one thing you really want to try and avoid, but actually are there some more civil ways, I guess, more amicable ways, let's say, of approaching this?
Yes. So, I mean, we always sort of approach it as court is the last resort. I think in finances, often it's common that you need the court process because that ensures that the court puts in place a timetable to put deadlines in place for disclosure, deal with any kind of disclosure issues that arise. But the great thing is, because the courts, in all honesty, are on their knees and they are so overburdened and under-resourced, and the delays are hideous, that now family lawyers really are using lots of different alternatives to try and avoid the court process altogether. So you have things like mediation, which is obviously a non-binding forum to try and resolve disputes. And the courts really encourage people to try that. If that's not appropriate or it doesn't resolve in an outcome, then a real kind of growth area in our practice, and it's finance and children related, is the use of private hearings, either private negotiation hearings or private arbitration, which is a kind of binding process. And the courts like it because it takes the cases out of their list. Clients like it because you do it in a much more civilized environment in someone's office. You have the time and the dedicated kind of expertise to enable settlement far quicker. And as a result, legal fees are lower because generally you settle much more quickly. And if you can't settle, arbitration, as I said, is there. We had a case last year. We desperately needed a decision by September because it was linked to where children went to school, where they should live. The court would have given us a date, I think it was May of this year. And instead we went to arbitration and, we got a binding decision really quickly. So it's definitely worth considering and something for all clients to consider. There are other options.
That's great. One other thing, sorry, just pinged into my brain, going back to the assets and everything. Does the same apply to international debt as well?
When you're disclosing your wealth as part of a divorce process, you have to disclose assets, debts, sources of income, any beneficial interests you have. So debts would be sort of on the asset schedule as something that needs to be considered. And often, if that debt has been acquired during the marriage, it would be considered a marital debt that has to be deducted to get to the sort of net pot before you divide up that pot. So the debts would all be taken into account as well.
Mm-hmm. And then how about unknown unknowns? So, assets that have effectively been hidden and don't surface for a while. What happens in that sort of case? So
I always say to clients, it is really difficult in England to hide assets because we have such an onerous disclosure process, and the court has sort of wide powers if someone doesn't disclose properly. So, for example, the very minimum, if you're in the court process for the finances, is that you get 12 months of bank statements for every bank account, in England or offshore. And if you can see transactions in that account that don't make sense or you can't identify, you have the opportunity to ask questions and to ask for more documents. And the court will order that if the other spouse isn't willing to provide it. I guess things like crypto are becoming far more commonplace, and it's important to be able to trace that. I think that's becoming more sophisticated as time goes on in terms of being able to trace it. So there are lots of routes to try and ensure that everyone is clear what the established pot is.
And I like that you brought up crypto. I remember I had a client whose husband or ex-husband had conveniently lost his key for his very convenient.
Yeah, we've seen that one a few times as well.
Yeah, like, what key? There was no key. There's no crypto. Yeah, it's fascinating. But thank you so much for all of that. And so final, do you want to just close sort of like what your key takeaway then for anyone who is considering getting married with an international angle?
Yeah, I think if you are getting married and you have wealth that you wish to protect, either because it's, let's say, family wealth that's gifted or inherited or is likely to be during the marriage, or you're bringing assets to the marriage that you want to protect, and it's likely that you will have a strong connection to this country, either because you're going to move here or you're living here or you're from here, it is worth having an exploratory chat with someone like me to give some outline of the process and to decide whether it's something that's worth considering. I would say that prenups are becoming more commonplace. Postnups remain much harder to get over the line than a prenup. So I would always recommend people take the advice early. If you don't do anything with it, fine, but at least you're informed and you can decide what's best for you.
Perfect. Thank you so much. And thank you to everybody who is watching us either live or on the replay as well. If you want to get hold of Katie, either reach out to me or directly to Katie herself. I'll share the details. And yeah, thank you again so much. Lovely to see you.
Thank you. Take care.
Bye-bye.
Bye.